At 6:47 a.m. Eastern on a Tuesday morning, Dow futures collapsed by 620 points within 11 minutes of the tariff announcement crossing newswires. The White House statement had been issued at 6:36 a.m., timed to precede market opening by less than 3 hours. By 8:15 a.m., Treasury officials confirmed to Reuters that no reversal was under consideration and that implementation would proceed on the announced timeline. What followed was not policy debate but institutional scramble. The U.S. Trade Representative's office had received no advance implementation guidance. Customs and Border Protection began operating under provisional enforcement assumptions with no finalized regulatory text. Canadian officials convened emergency cabinet sessions while their own markets opened under uncertainty. The Securities and Exchange Commission activated volatility monitoring protocols designed for system shocks, not trade policy. Within 72 hours, agencies across 2 federal governments were functioning under crisis procedures with no shared legal framework, no synchronized timeline, and no procedural roadmap for resolution. The tariff order cites Section 232 of the Trade Expansion Act of 1962, a national security provision originally designed for defense-critical materials during Cold War supply vulnerabilities. Congress enacted Trade Promotion Authority in 2015 specifically to govern broad tariff actions, establishing consultation requirements, impact assessments, and legislative review windows. Neither statute anticipated unilateral invocation against the largest trading partner without congressional notification. The Department of Commerce is statutorily responsible for certifying national security threats under Section 232, but no formal threat assessment was published before the announcement. The legal challenge pathway remains undefined. Federal district courts can hear constitutional claims, but no precedent establishes which circuit has proper jurisdiction for pre-implementation review. The Court of International Trade traditionally handles tariff disputes, but only after goods are detained and duties assessed. Administrative Procedure Act timelines require 30-day comment periods for regulatory changes of this magnitude, yet implementation is scheduled in 14 days. No federal agency has published guidance on which judicial review process governs, what standing requirements apply, or whether preliminary injunctions can halt enforcement before economic damage occurs. 3 separate legal frameworks now claim jurisdiction over the same executive action with no institutional mechanism to resolve the conflict. Within 48 hours of the U.S. announcement, Canada's Department of Finance published a 142-page counter-tariff schedule with implementation set for March 15. The document targets $30 billion in American goods across 73 congressional districts, concentrating on Wisconsin dairy processors, Michigan automotive parts suppliers, and Kentucky bourbon distilleries. This is not diplomatic signaling. Cabinet ministers have already signed implementation orders. Provincial premiers have coordinated enforcement through Canada Border Services Agency field offices. The strategy is surgical. Identify districts where economic pain translates to political pressure, then activate tariffs with legal precision. The United States-Mexico-Canada Agreement, ratified in 2020, contains explicit prohibitions against unilateral tariffs outside dispute resolution procedures outlined in Chapter 31. Article 32.2 requires 90-day consultation before any trade remedy action. Neither government invoked these provisions. The USMCA establishes binational panels to adjudicate tariff disputes, but both nations are now implementing tariffs that bypass this treaty-mandated process. 2 legal enforcement systems are being constructed in parallel, each claiming treaty authority, neither recognizing the other's jurisdiction. No mechanism exists to reconcile them before goods are stopped at borders. The Federal Reserve's dual mandate requires maximum employment and stable prices. Tariffs of this magnitude directly impact both through supply chain costs and retaliatory job losses. Yet the central bank has issued no statement, revised no economic projections, and offered no guidance to markets now pricing in uncertainty the Fed itself cannot quantify. Internal Federal Open Market Committee communications obtained through Freedom of Information Act requests show emergency conference calls scheduled within hours of the tariff announcement, but no public readout was released. The Fed's March interest rate decision is now 17 days away. Monetary policy functions through forward guidance. The central bank signals future rate paths so markets can price risk accordingly. That mechanism has collapsed. The Fed cannot credibly project inflation without knowing whether tariffs will be implemented, expanded, or withdrawn. It cannot comment on executive branch trade policy without violating institutional independence. It cannot remain silent without abandoning its stability mandate. Goldman Sachs and JP Morgan have suspended quarterly economic forecasts, citing non-modelable policy volatility. The European Central Bank issued a rare statement noting that US monetary policy transmission has become institutionally opaque. Markets are now operating without the anchor institution designed to prevent exactly this kind of cascading uncertainty. The world's reserve currency is being managed by a central bank that cannot speak. Cuban heavy crude has entered North American supply chains through Venezuelan state oil company transactions that Canadian refineries have processed under licenses issued before current sanctions, tightening. The Treasury Department's Office of Foreign Assets Control maintains a sanctions list prohibiting transactions with Cuban state entities under the Cuban Assets Control Regulations, codified in 31 CFR Part 515. Canadian refineries in Quebec and New Brunswick process multiple crude grades simultaneously, blending Venezuelan, Saudi, and domestic Canadian feedstock into refined products that cross into the United States through pipeline networks managed by private operators. No existing enforcement protocol allows customs officials to determine the national origin of molecules in a blended petroleum product. OFAC licensing requirements demand documentation proving no Cuban origin crude has entered the supply chain, but refineries operate continuous processing systems where crude sources mix in storage tanks before distillation. The administrative burden is backward. Enforcement staff must prove Cuban presence, but chemical composition testing cannot distinguish Venezuelan crude from Cuban crude extracted from geologically identical formations. Customs and Border Protection field offices have requested interagency guidance on inspection protocols, acceptable documentation standards, and detention procedures for suspected sanctions violations. No guidance has been issued. The Department of Energy has convened meetings with Treasury and Homeland Security to develop enforcement coordination, but no agreement has emerged on which agency has primary jurisdiction. Shipping companies have filed compliance inquiries asking whether Canadian certificates of origin satisfy OFAC requirements if Cuban crude entered the refining process months earlier. The inquiries remain unanswered. Tankers are now holding in Canadian ports awaiting legal clarity that no federal agency can provide, while contracts for delivery face force majeure declarations due to regulatory impossibility. 43 oil and natural gas pipelines cross the US-Canada border under operating agreements negotiated between 1950 and 2018, all predicated on uninterrupted binational energy flow. The Enbridge pipeline system moves 3 million barrels daily from Alberta to Midwest refineries through infrastructure governed by joint operating committees with no provisions for tariff-induced shutdowns. Electrical grid integration connects 6 Canadian provinces to US regional transmission organizations, with real-time load balancing managed by the North American Electric Reliability Corporation under standards that assume cooperative cross-border flow. The International Joint Commission, established by the Boundary Waters Treaty of 1909, manages shared waterways including the Great Lakes Navigation System that handles 40% of Canada-US trade volume. None of these frameworks contain protocols for one nation imposing trade barriers while maintaining critical infrastructure dependencies. Customs enforcement of tariffs on energy products requires physical inspection and potential detention of shipments at border crossings. But pipeline systems operate continuously with no infrastructure for halting flow without triggering pressure failures across binational networks. The Department of Homeland Security has statutory responsibility for tariff enforcement through Customs and Border Protection, while the Department of Energy maintains regulatory authority over cross-border energy infrastructure through the Federal Energy Regulatory Commission. No interagency process reconciles these mandates when they conflict. Canadian Border Services Agency coordinates with provincial utility regulators to maintain grid stability, while federal trade enforcement offices prepare retaliatory inspections on southbound energy flows. Technical staff managing physical infrastructure report to agencies with stability mandates. Trade enforcement personnel report to agencies with revenue and compliance mandates. No single governmental authority in either country has jurisdiction over both systems, and no bilateral commission has convened to address the collision. The World Trade Organization's dispute settlement understanding establishes binding procedures for adjudicating trade conflicts between member states. Article 21 of the General Agreement on Tariffs and Trade permits national security exceptions to trade obligations, but requires members to demonstrate that measures are necessary for the protection of essential security interests. The United States has invoked Article 21 without publishing threat assessments, intelligence justifications, or defense procurement documentation that would substantiate the national security claim. Canada has indicated it will file a formal complaint with the WTO dispute settlement body, triggering a procedural sequence established in the 1994 Marrakesh Agreement. Under WTO rules, consultations between parties must occur for 60 days. If unresolved, a dispute panel is established within 45 days, composed of 3 trade law experts selected through a process that typically requires an additional 30 days. Panel proceedings include written submissions, hearings, and interim review, consuming 6 to 9 months before a preliminary ruling. Final reports are issued to members 90 days after preliminary findings, followed by a 60-day adoption period. Appeals to the appellate body, if the losing party requests, add another 90 to 120 days. The complete timeline from complaint filing to enforceable ruling averages 18 months. Tariffs are being implemented in 14 days. Economic damage, factory closures, contract cancellations, supply chain ruptures occurs in real time, while the international legal system designed to prevent exactly this scenario proceeds at a pace measured in seasons. The framework indicts itself through its own procedural requirements. Article I, Section 8 of the Constitution grants Congress exclusive power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. The tariff order was issued without congressional vote, without committee hearing, and without consultation with House Ways and Means or Senate Finance leadership. No legislative authorization exists. The executive branch claims inherent presidential authority under the 1962 statute that delegated national security trade powers to the executive, but that delegation itself requires congressional oversight mechanisms that have not been activated. The Senate Finance Committee has scheduled no hearings. The House has introduced no resolution. No constitutional procedure allows Congress to ratify tariffs already being enforced at ports of entry. Federal courts can issue rulings on constitutional challenges, but judicial remedies cannot reverse tariffs already collected or contracts already breached. Preliminary injunctions require plaintiffs to demonstrate irreparable harm, but economic damage is occurring continuously, making the harm both irreparable and ongoing in ways that defy traditional injunctive relief standards. Congress could pass legislation overriding the tariff order, but requires 2/3 majorities in both chambers to override a certain presidential veto. No such coalition exists. The executive branch has signaled through White House counsel statements that national security determinations are constitutionally unreviewable, citing precedent from wartime executive actions. The judiciary can declare the tariffs unconstitutional, but cannot compel their removal without enforcement mechanisms that depend on executive branch cooperation. Congress holds appropriations power, but cannot defund tariffs that generate revenue rather than consume it. 3 co-equal branches of government now occupy positions where each can block the others, but none can resolve the crisis. The tariff order invokes national security to justify restrictions on the nation that supplies 52% of U.S. crude oil imports and 100% of heavy crude grades required by Gulf Coast refineries designed specifically to process dense Canadian bitumen. Midwest refineries in Minnesota, Wisconsin, and Michigan operate on configurations optimized for Canadian heavy crude, with no technical capacity to switch to lighter domestic shale oil without infrastructure investments requiring 3 to 5 years. The Department of Energy's Office of Fossil Energy published an internal assessment in December 2024, concluding that disruption to Canadian energy imports would create immediate and severe supply shortages in regions with no pipeline access to alternative sources. The Pentagon's Defense Logistics Agency, responsible for military fuel procurement, issued guidance to U.S. Northern Command noting that jet fuel supplies for bases in Alaska, Montana, and North Dakota depend entirely on Canadian refinery output, with no domestic substitution available within current contract structures. The national security justification for the tariffs cites energy independence, yet the mechanism of achieving that independence, restricting the largest and most reliable foreign supplier, creates the exact vulnerability the policy claims to prevent. Energy security doctrine has inverted. The cure is the crisis. Financial markets require legal predictability to price risk. Federal agencies require jurisdictional clarity to execute policy. Allied governments require procedural frameworks to negotiate resolution. None of these conditions exist. The institutional architecture of trade governance was designed assuming congressional authorization, judicial review timelines that precede implementation, and treaty structures between cooperative partners. That design has failed. This is not ideological disagreement, but structural impossibility. Courts cannot resolve what they cannot reach. Congress cannot authorize what is already executing. Diplomats cannot negotiate without knowing which domestic authority holds final decision power. Each day of continued enforcement compounds the fragmentation. Contracts are breached and cannot be restored. Supply chains are severed and cannot be instantly rebuilt. Legal precedents are established and cannot be unwritten. The crisis is self-executing, generating its own momentum through procedural logic that no institution can interrupt. No legislative remedy, judicial intervention, or diplomatic agreement can restore the conditions that existed before the system was activated. The framework has collapsed under assumptions it was never built to survive.